So what's the purpose of a dissenting judgment? By definition, you're already not going to make any law because a majority of judges are on the other side. But the law is not a static beast. The law changes, the law evolves. Experience is an important factor. The extent to which the police are respecting the rights of a detained person is important. And in some countries, there is the tradition of unanimous judgment. The court simply says, here is the result. The value of our system is that we bring the public into the debate so they can see that while 5 judges have one point of view, there are 4 judges who have a different point of view. And therefore the debate is ongoing. The question is not as clear as eventually it may become. So it's a way of public education, it's a way of attracting public input, it's a way for the dissenting judges to vent frustration with what the majority is saying. And all of this contributes to the evolution of the Charter, because the next case that comes along, maybe the court will say, well, in the earlier case we went a bit too far, we've let the police exercise more power than was really intended. Or if a decision is the other way, the reaction may be, well, society is suffering because the police can't adequately investigate cases, because whenever they pose a question, the suspect simply shuts up or calls for a lawyer, or otherwise obstructs, gets in the way of the investigation. So that's generally, when you ask about a dissenting judgment, as I mentioned, when there are different views on the court, every judge is entitled to express an opinion. Usually we sit 9 judges, so there are 9 potential opinions. We make an effort as a court to at least get 5 judges on the same opinion, because then the profession and judges and the professors and everybody else know, well, that opinion expresses the law. Beyond that, you can have judges who agree with the result, but they have different reasons, and that's called a concurring opinion. And the reasoning might be quite different from the majority reasoning. And then you will get a dissent where the judge agrees neither with the outcome nor with the reasoning, and feels compelled to put pen to paper and write a stinging dissent, as they're usually called in the press. And in a sense, it's a sign of defeat, because you've been unable to carry a majority of your colleagues. And of course, the object of the game is to have a majority and to speak for the court and have your views accepted as a proper interpretation of the Charter.